This is the next case on the docket, Murphy versus Inman. It is also a 15-minute mini oral argument on the application. That means you each have 15 minutes, and Mr. Schreiner, you can do your best to reserve some of that for rebuttal, and if you are ready to go, you may proceed.
Thank you, and may it please the court, Miles Schreiner of Monteverde and Associates for the plaintiff, Mr. Murphy, and I'd like to reserve 3 minutes for rebuttal. The Covisint merger resulted from a sales process that defendants initiated after mounting shareholder criticism of their job performance and threats to remove them. During the process, the defendants favored open text, while other interested bidders were treated adversely. They agreed to merger consideration that they knew grossly undervalued shareholder shares. They concocted or used baseless valuations to try to justify the deal, and they disseminated a materially deficient proxy statement to solicit shareholder approval. The defendants' conduct in orchestrating the merger constituted a breach of the fiduciary duties they owed to the company's shareholders. And when my client and other shareholders had their Covisint shares, their own personal property, cashed out in the unfair merger, they, and not the corporate entity, suffered the injury. This simple fact has been recognized by numerous courts across the country, and it means that plaintiff has standing to bring a direct action against Covisint's directors and officers. This court should reject the regime that's been created by the lower courts, under which shareholders of Michigan corporations are left without any recourse for their injury in an unfair cash-out merger. Yesterday, Justice Bernstein said his mantra was, the law should make sense. And characterizing plaintiff's claims as derivative makes no sense. Doing so means that any recovery would flow solely to open text, which is the entity that's already paid too little to the cashed out shareholders. Now, with respect to the duty to maximize shareholder value when contemplating a cash out merger, the Court of Appeals stated that the duty is not owed directly to shareholders independent of the corporation, and that's simply a fundamental misunderstanding of corporate law. That duty is owed strictly to the owners of the shares, which are the shareholders, and does not run to the corporate entity, which does not own itself. With respect to the duty of candor, the Court of Appeals wrote that the harm done is to the corporation, but again, that conclusion is defied by the reality of corporate voting rights. The harm is plainly to the shareholders, the ones who are entitled to make an informed voting decision, not the corporate entity, which has no voting rights on the merger. And we ask that this court correct the Court of Appeals errors. It should clarify that Michigan common law test set forth in McGrath by articulating the test in the manner that the Delaware Supreme Court did in Tooley, which really focuses on who suffered the harm and who would receive the benefit of the recovery. And that test has been adopted in numerous states, and it's really just a clear articulation of the concepts in McGrath. Nothing.
Mr. Schreiner, let me interrupt you and see what questions my colleagues have, and then we can get back to you if there are none. Justice Clement.
No questions right now. Thank you.
Justice Cavanagh.
No questions.
Justice Welch.
No questions.
Justice Zahra.
Yes, I'll bite. It seems to me Delaware rejects the notion that the complaining shareholder must suffer a loss distinct from other shareholders. Not quite sure that's the rule in Michigan. I see a clear path to recovery for you or your client if we adopt the Delaware standard articulated in Tooley. But if we don't adopt Tooley, can you prevail under current Michigan law?
I think so, Your Honor. I think Tooley is largely in harmony with the test in McGrath. McGrath asked, who's the duty owed to, and has the shareholder suffered a harm that's separated from any harm to the corporation? It's using slightly different words, but the concept it's getting at is congruent with what the Tooley test is. The test Your Honor was referring to, I think, is a separate test that this court recognized in Schreiner, the special injury test. We don't think we have to go there today. We're focused on McGrath, clarifying McGrath, and I think the easiest way to do that is using the verbiage in Tooley just because there's a greater body of case law out there that has utilized that verbal formula. But again, I think it's entirely consistent with what the Court of Appeals said in Majette. So I don't think it's rewriting Michigan law, it's simply clarifying it.
What would that result do to Christner, though?
I think Christner stands as it is and is just another path, if you will, for shareholders to bring a direct action. That path seems to apply more in probably closed corporations where you have perhaps one specific shareholder who's being treated differently than others. It doesn't necessarily arise in the public corporation context.
Thank you.
Justice Viviano,
No questions. Thank you.
Justice Bernstein.
No questions, thank you.
All right, counsel, you may continue or reserve time, up to you.
Sure, I'll continue. I want to turn to section 541A, and nothing in the text of that statute or in any other provision of the Michigan Business Corporation Act prohibits the outcome that we're asking for here today. Conversely, holding that 541A prohibits enforcement via direct action requires adding words to the statute that simply aren't there. And I think it's important to consider the context of when the statute was last revised. The operative version is 1989. At that point in time, the legislature is presumed to have known of the deep body of Michigan common law articulating these concepts of a duty to maximize and a duty of candor. And if you read the case law, much of it is actually tied to this concept of good faith. For example, in Dodge v. Ford, which is obviously a seminal case from this court discussing shareholder primacy and the concept of maximization, the term good faith is referenced 3 times. So I believe the court was tying this concept of maximization to good faith. When the legislature acts in 1989, it also knows that this court has established these common law tests for determining when a shareholder can bring a direct action. And there's nothing in the text of 541A that indicates that the legislature meant to abrogate those well-established bodies of common law. To the contrary, subsection 4 of the statute plainly contemplates an action against a director or officer for failure to perform the duties imposed therein by unnamed complainants is the term. And it reaffirms this concept of good faith in section 1A. And so where that leaves us, I think, is if anything, the legislature knows of this body of common law. It does nothing to abrogate it. If anything, it reaffirms that there is this concept of a direct action and this concept of good faith. So I think the outcome we're asking for today is entirely consistent with the legislative scheme. And if there's no further questions at this time, I will reserve the balance for rebuttal.
Any further questions right now for Mr. Schreiner? Okay, you may reserve. Mr. McGrath.
Yes, thank you, Your Honor. Again, I'm Chris McGrath of Paul Hastings, and I represent the individual directors and officers, former directors and officers of Covacent. If I only had a minute before you to argue, what I'd say is this is a simple case. The Court of Appeal decision distills and captures existing Michigan law established and developed in this area and applies it. It's contrary to some of the arguments we heard from plaintiff and then some from the amici briefs. There's no uncertainty created by this decision. In fact, it was entirely predictable when plaintiff filed it, and which begs the question as to why did plaintiff pursue the remedies in this manner rather than seeking to enjoin the transaction as the federal shareholder complainants did, particularly if it thought the process was flawed and the proxy statement was misleading. Why in the world would they want the shareholder group, shareholder class that they purport to represent to vote on a merger transaction, which was, according to their theory, being decided upon a flawed proxy statement? But they made that choice. They made that choice to sit on their hand, even though they filed their complaint 4 weeks after the merger was announced on June 5th, 2017. They filed their complaint on June 30th, and the merger didn't close until July 26, 2017. So there was ample time, as demonstrated by the other federal plaintiffs in this case, for them to seek to enjoin the shareholder meeting and stop the vote, and they didn't do that. But what their What counsel's recitation of their allegations does establish, however, is this is not a case where it's simply a cash out merger and the only theory is a common law duty to maximize shareholder value. And that's kind of the premise that both the amici briefs adopt and plaintiff. And that's not the case here. What we really need to do is look at what they've alleged. They've alleged, as the Court of Appeals noted in its opinion, that defendants breach many of their fiduciary duties while making strategic decisions during the process of arranging Covisant's merger with OpenText by making a decision to sell, creating and failing to prevent the adverse consequences of the sale, and failing to disclose material information prior to the vote. That's the proxy claim that I mentioned. And those are claims that harm the corporation. So we aren't in a vacuum or a hypothetical that the amici briefs seem to engage in, or how plaintiff would like to recast their 541A claim as a purely common law claim that they're operating under. They only brought one claim for breach of fiduciary duty, and that was that invoked Section 541A under the Business Act. They did make some references to the common law within it, but it's one claim, and they invoke the statute.
Counsel,
Now-
let me interrupt you and get to questions, then we can come back to you if there's time. Justice Clement,
No questions. Thank you.
Justice Cavanagh,
No questions.
Justice Welch.
Thank you, Mr. McGrath. I do have a question. You were just saying at the end of your opening there that the corporation itself was harmed here. And I actually am trying to figure out how it was harmed, because it seems, and this has obviously been raised in the other briefs, that OpenText essentially is getting the benefit twice. First, by acquiring Covisant at the arguable discount, and then second, if there were a lawsuit and damages, they would essentially get to acquire the difference in the undervaluation, if you will. And I'm just wondering how that's harm to the corporation.
Well, in a couple of ways, Your Honor. One is the manner we discussed when we were at oral argument before the Court of Appeals panel. And that was, imagine that the merger had not been consummated. And yet the board had agreed to a share price that, as plaintiffs theorize, materially undervalued the company. Then the company would have to proceed and act with that lower share price, which would harm it in terms of what its market capitalization was, its ability to borrow, its use of its stock as currency to make acquisitions. And at the time the complaint was filed, the merger was not consummated. So that at the time the complaint was filed, that's alleging harm to the corporation. Secondly, the outcome that you postulate is solely a product of the plaintiff's choices. Again, they didn't attempt to enjoin the merger beforehand. Had they brought a derivative claim at the time they filed their complaint and enjoined the transaction, if they could have established all the grounds that they've alleged in their complaint, the merger would not have been consummated, and any recovery would have belonged to Covisant, in which they are shareholders. So it's sort of a false predicate on their part to, again, lie in the weeds, sit on their hands, don't attempt to enjoin the merger, which plaintiffs virtually always do, and then to complain later when the transaction went through, and then, oh, by the way, we're operating under Michigan law, which has decided that these types of claims are derivative in nature, which they knew and they're on notice of because there was no mystery about that. So again, it's not the case where they had no other options and they're in this dilemma, but for their own choices and their own strategy. And so we're either here dealing with a Court of Appeals decision that represents established Michigan law that's on notice to all, because they made errors or decisions at the outset they're trying to remedy, or we're all participating in an experiment where they're trying to import Delaware law and references from the Model Act, not the Michigan Business Act, in order to re-legislate and rewrite Section 541A. And one of the comments that the panel made, and I believe it was Judge Godola, asked plaintiff, isn't this a policy decision? Isn't the manner in which 541A, what the legislature intended, isn't that a matter for the legislature? Why shouldn't you take that up with the legislature and not pose that to the courts? And I can keep going to the balance of my argument, or if you've
I
Yes,
will
sure.
cede because I know others may have questions. So thank you.
Yeah, thank you, Mr. McGrath. Justice Zahra,
Questions, thank you.
Justice Viviano,
No questions.
Justice Bernstein.
Good morning, council. I just want to kind of stick to my normal trend of using a common sense application to all these different cases and issues that lie before us. And I guess I'm just going to kind of pose this question to you in this perspective is that ultimately, don't you feel in this situation that there needs to be a vehicle or a venue as it pertains to all the facts that have been, put forth to allow for those who are in charge of corporations to be held accountable by their shareholders, or at least allow for the shareholders to present argument to have a better appreciation and understanding as to what might have taken place here.
Well, thank you, Your Honor. Well, there are many vehicles. As I stated earlier, experienced plaintiff counsel on the other side, they bring a lot of these cases. We face them all the time. They chose not to seek to enjoin the transaction. That would have been a process where they could have done it under Michigan law, utilizing the tools 541A to challenge it and again hold the board accountable if in fact their allegations had weight. But those aren't the only remedies they had. They also had the ability to vote against the merger. But beyond that, they could have pursued federal remedies. They pursue those all the time. They're very familiar with that. As I said, we had 3 plaintiff shareholder complaints filed in federal court alleging that based on the proxy statement regulations of the SEC. They could have brought claims there also to hold, and those don't have derivative direct issues there. So there are lots of tools in the toolbox for the plaintiffs here. They just selected to pursue the one that Michigan law forecloses if not brought immediately.
Thank you, counsel.
Thank you.
You may continue now, counsel.
Okay. So one point that I want to note that neither the amici briefs or plaintiff in their reply brief to our supplemental briefing on the common law duty and standing questions the court requested was our observation that 541A and this area of the Business Act is a comprehensive legislative scheme. And we cited a number of authorities, Milross, Pollock, Powell, where by enacting such a comprehensive scheme, which addresses duties, exceptions, remedies, limitations periods when they can be brought, courts have found that it preempts and supersedes any prior existing common law. Neither the plaintiff's reply brief nor either of the amici briefs address that line of authority whatsoever. And that's our perspective. That's not the perspective that was followed by the Court of Appeals decision that we're dealing with today. In fact, the panel below recognized the existence of common law duties. So this is not a parade of horribles where somehow the decision that we were arguing should remain intact eliminates common law duties. It doesn't. It recognizes them and then goes through the existing tests under Michigan law to determine whether plaintiffs have a direct claim or not. Following Christner, following Jet, following Bell Island. It's not a case that goes anywhere near the business judgment rule, much less eliminating it, which was another parade of horrible that we were confronted with. It went through that analysis of direct versus derivative and found that it made absolutely no difference in the outcome in terms of whether the plaintiffs had standing or not. The Court of Appeal decision also recognized the common law duty of candor. So it didn't break any new ground. And from our perspective, there's no reason to disturb the panel's decision below. It's an unpublished order. It's fully consistent with all the published and unpublished authority in this case. That is why the plaintiffs and the amici have gone to Delaware or gone to the Model Act in order to manufacture an argument about how Michigan law should change. And from our perspective, that's the purview of the legislature, and they're welcome to take that up with them. One point I just wanted to raise, I see I have a few minutes left, is that the Tooley decision, we don't think it's necessary for the court to take the journey to Delaware common law at all. For one thing, Delaware didn't adopt a model act like Michigan did. It didn't codify its fiduciary duties like Michigan did. So it's a different scheme. But nonetheless, the Tooley case is not as unchanging and irrevocable as plaintiffs have suggested the Tooley standard. In September of this year, so just a few months ago, in a case called Brookfield Asset Management versus Roson, Lexus 291, and it's September 20th, 2021, the Delaware Supreme Court gave additional attention to Tooley. And Tooley was not itself a cash-out merger case, and neither is Brookfield. But in looking at, and so in determining whether a case is direct or derivative, you have to analyze it on the facts in every case. And in the Brookfield case, in running through that test, which alleged a diminution in value to company shares, which derivatively diminished the value of the shareholders' interest in those same shares, looked at the remedies that Brookfield looked at the remedies that the plaintiff sought. And one of the remedies that the plaintiff sought in Brookfield, which persuaded the court that it was a derivative claim, was that it sought rescissory damages. And if you look at the complaint and the First Amendment complaint that plaintiff Murphy has filed in this case, they seek rescissory damages, which is a corporate remedy, not a remedy for the individual shareholders. So again, we don't think it's necessary to go down the road of adopting, importing, analyzing, trying to keep up with Delaware precedent on this test. The Schreiner test is time tested, and the traditional direct derivative analysis test that we all learned in law school. But if it did, what I would suggest to the court is that it also look at the Brookfield case and understand that test is evolving somewhat, and the fact that plaintiffs sought a corporate remedy doesn't favor the outcome that they're advocating. So we think the outcome's clear under 541A, as the Court of Appeal noted. It addresses the duty of director and officer to act in the best interest of the corporation. The Court of Appeal panel focused on that language, and it was consistent with the notion in the prior precedent that views this as a corporate claim. Plaintiff made reference to some earlier decisions, a pre-codification in Michigan, which talked about the duty of good faith. Well, 541A, sub 1, sum A, the first duty there is to act in good faith. So it's clear that the legislature already recognized the duty to act in good faith, and it's part of 541A. And so it'd be difficult to conclude from that they meant to reserve that development to common law because it's codified. And again, under the preemption and legislative scheme analysis in Pollock, Milross, and Howe, we believe that that's demonstrative of the legislature's intent. So with that, I'll conclude, Your Honor, and thank you for your time.
Thank you, Mr. McGrath. Mr. Schreiner, you have some rebuttal time.
Yes, thank you. Justice Welch asked a very straightforward question of my colleague. How was the corporation harmed from any of the alleged misconduct? And respectfully, he said a lot of words, but he didn't answer the question. And I understand why, because there's no clear answer. He hypothesized about what would have happened if the merger wasn't consummated. But those aren't the facts of this case. The merger was consummated. My client and shareholders had their shares taken from them for inadequate consideration. And he's repeatedly, what I believe, conflating issues. He's talking about litigation strategy, what we should have done. We should have sought to enjoin the merger. But through which vehicle? That's the fundamental question at issue here. And this notion that the derivative proceeding is the right vehicle to use for whatever form of relief you're seeking is simply incorrect. And that's because the derivative vehicle is meant to remedy a harm to the corporation, which just does not exist based upon the facts alleged in this particular case. And again, I think there was some conflation of Schreiner versus Majet by my colleague. I think Schreiner can be left alone for now. I think the simplest path forward in this case is to just clarify the test in Majet using some of the language in Tooley that'll put Michigan in line with other jurisdictions, and it'll give litigants and courts a developed body of case law to follow in this area. I'll turn lastly to section 450.1103, which the legislature instructed the courts to liberally construe the act in order to promote its purposes, including to simplify, clarify, and modernize the law governing business corporations. And I think the relief we're asking here for today would be entirely consistent with that statute's instruction. So we would ask that this court reverse so that shareholders can pursue justice. And unless the court has any other further questions, I'll leave it there.
Are there any additional questions for Mr. Schreiner? Thank you both for your presentations. The case will be submitted.